The determination of an appeal challenging the election of Wilfred Lesan as Bomet senator set the stage for another clash over the proper age of retirement for judges. Through his lawyer, the petitioner Nick Salat wrote to the court questioning the presence of Justice Philip Tunoi on the bench that had the case, bringing up the fact that Tunoi is 70 years old and should not hear any cases following the Judicial Service Commission's contested decision to retire judges at the age prescribed by the 2010 Constitution. Four Supreme Court judges Ndungu, Kalpana Rawal, Philip Tunoi and Ojwang would rule that the Judicial Service Commission has no mandate to interfere with the judge's tenure.
This court takes the position that the security of tenure for all judges under the Constitution of Kenya 2010 is sacrosanct, and it is not amenable to variation by any person or agency, such as the Judicial Service Commission, which has no supervisory power over judges in the conduct of their judicial mandate. We find and hold that the Judicial Service Commission lacks competence to direct or determine how or when a judge in any of the superior courts may perform his or her judicial duty, or when he or she may or may not sit in court. We hereby signal that the court's bench, as constituted by the learned justices who rendered service in this case, indeed bears the constitutional mandate to hear and determine the cause in hand, notwithstanding the apprehensions of learned counsel.
Rawal, the Deputy President of the Supreme Court, and Tunoi have already filed cases challenging the JSC's order retiring them. The retirement factor, a controversial topic that has seen some judges withdraw their labour as a succession race for Chief Justice Willie Mutunga's seat heats up. But while Mutunga, the President of the Supreme Court, agreed with the final decision, dismissing Salat's petition, he held a dissenting opinion in regard to the other judges' decisions.
There was no hearing on the contents of the letter. The other parties were not given the opportunity to respond to the letter, and hence were not heard. Therefore, in arriving at the finding and the holding on the contents of the said letter, they violated the fundamental principles of due process of the law pertaining to the parties and the Judicial Service Commission, which was not party to the appeal.
The case could open floodgates for litigants to reject decisions made by judges who have attained the age of 70. Rawal and Tunoi argue that they were hired before 2010 and should therefore be retired at the age of 74, as prescribed by the law then. Mutunga has said he will retire in 2016, a full year before he was expected to leave office. Wilkes Anyabwa, Monday Special.